Have you ever had an insurance company make your first offer that felt way too low? That first number the adjuster gives you, $4,200 for a crash that kept you out of work for 3 weeks, is never what your personal injury case is actually worth in Colorado. Here's how they really calculate that number behind the scenes and the hidden deductions they never say out loud before they hope you sign. Stay with me, because the biggest one alone can erase a third of your settlement. Let's start with the number they gave you, because that's usually the smallest, honest offer they're willing to make, and it's designed to test whether you know any better. In Colorado, personal injury settlements are built from two main categories: economic damages, which are the numbers you can put on paper, medical bills, lost wages, property damage, future medical care if your injury requires ongoing treatment, and non-economic damages, which is the legal term for pain and suffering. That second category is where almost every disputed dollar in a Colorado Springs settlement lives, because pain and suffering doesn't come with a receipt. Here's how the insurance companies actually calculate it internally, and this is the part that rarely gets explained. They take your total medical bills and apply what's called a multiplier, typically somewhere between 1.5 and 5, depending on how severe and how well documented your injuries are. A herniated disc with an MRI and a specialist's opinion multiplies very differently than a soft tissue strain with 2 urgent care visits. The insurance company's opening offer almost never reflects the multiplier your case actually deserves. It reflects the multiplier they're hoping you'll accept before you understand there's a range at all. Now, here's the hidden deduction nobody explains, and it's the biggest one. In Colorado, we use a modified comparative negligence rule. If you're found even partially at fault for the accident, your settlement gets reduced by that percentage. And if you're found 50% or more at fault, you get nothing. So the first thing an adjuster does on every single call is try to get you to say something that assigns even a 10 or 15% of the blame. Did you see the car coming? Were you looking at your phone at all? Those aren't casual questions. Every answer you give on a recorded statement is being measured against that fault percentage, because every point of fault they can pin on you is a point they don't have to pay. The second hidden deduction is medical gaps. If you wait 2 weeks to see a doctor after the crash, or you skip a few physical therapy appointments because work got busy, the insurance company will point to that gap and argue your injuries couldn't have been that serious, or that something else caused the pain in between. I've seen adjusters cut settlement offers by thousands of dollars over a 2-week gap in treatment that had nothing to do with the actual injury. It doesn't matter that you were juggling a job, kids, and a car that was in the shop. On paper, that gap becomes a talking point for the adjuster, and it gets repeated every time the file changes hands internally. Consistent, documented care isn't just good for your health, it's the paper trail that protects the value of your claim, and it's one of the easiest things to control. There's a related mistake that costs people just as much, and it happens on social media, not in a doctor's office. Adjusters and their investigators look at public posts after a claim is filed. A photo of you at a birthday party smiling, a post about a weekend hike, even a check-in at the gym. All of it can be taken out of context and used to argue your injuries aren't as limiting as your medical record suggests. You don't have to stop living your life, but understanding that your online activity becomes part of the file is something most people never think about until it's already been used against them. The third factor that moves the number more than almost anything else is future medical costs. If your injury is going to require an ongoing treatment, physical therapy, injections, possible surgery down the road, that has to be accounted for in the settlement. Because once you sign a release, you can't go back and ask for more money later, even if your condition gets worse. This is why an early settlement offer made before your doctor knows your full recovery picture is almost always too low. The insurance company knows the clock works in their favor. The longer your case stays open, the more your treatment reveals about the real cost of your injury. And that's exactly why they want you to sign fast. Property damage plays into this too, more than people expect. A harder impact tends to correlate with more serious injury in the eyes of an adjuster, and eventually a jury. So the photos of the vehicle damage, the police report, even the repair estimate all become part of building the value of a personal injury case here in Colorado Springs. I've had adjusters try to argue that low visible damage to a bumper means low impact force, even when the client walked away with a herniated disc. That argument falls apart quickly once an accident reconstructionist expert or a treating physician explains that vehicle damage and human injury don't scale the same way, especially in newer cars built to absorb impact in the frame instead of the cabinet. One more piece people rarely factor in is lost earning capacity, which is different from lost wages. Lost wages cover the paycheck you missed while you were out. Lost earning capacity covers what happens if the injury limits what kind of work you can do going forward, whether that's a construction worker who can no longer lift the way the job requires, or someone in a physical role who has to shift to lighter duty at reduced pay. That number, when it applies, can dwarf every other category in this claim, and it's almost never included in an adjuster's first offer because it requires medical testimony the insurance company hopes you never gather. So when someone asks me how much their case is worth, the honest answer on that is it depends on documentation, timing, and whether anyone pushed back on the first number. I've represented people who were offered $4,200 on their first call and ended up with a settlement many times that amount once the medical records, the wage loss, and the future care needs were properly presented. The number that comes first is not the number the case is worth. It's the number the insurance company hopes you will accept before you find out otherwise. If you're dealing with an adjuster, call now. Don't give a recorded statement and don't accept the first number, no matter how final it sounds. Get your medical treatment fully documented first. That single step protects more settlement value than anything else you can do. I'm putting together more videos on exactly this kind of situation, what to say to an adjuster, what happens with uninsured drivers, what to do in the minute right after the crash in Colorado Springs. Subscribe so you don't miss those. And if you're dealing with an injury claim right now and want someone to look at what you're being offered, our contact information is in the description. Tell me what number they gave you in the comments, and I'll tell you whether that sounds like a real offer or a starting point.